Thank you, Mr. Senate President. My distinguished colleagues, I am Senator George Thompson Sekibo. I represent the Rivers East Electoral District. Mr. President, a motion on the urgent need to repeal the judgment of the Federal High Court Umuahia on suit number FAC/UM/CS/26/2020 on Section 84, subsection 12 of the Electoral Act 2022. Mr. President, there are about 80 or more co-sponsors. Some names were inadvertently omitted. They include Shaibi Esa Lau, Yusuf Abubakar Yusuf, and Senator Emmanuel Boacha. Having said that one, may I crave your indulgence to move the motion.
You may proceed.
The Senate, aware that the Senate of the Federal Republic of Nigeria passed the Electoral Bill 2022 and a clean copy forwarded to the President of the Federal Republic of Nigeria for his assent. Aware also that the President, Federal Republic of Nigeria, assented to the bill into law, which was widely appreciated by the citizens of the country. Observe that a court in Umuahia State, in a suit marked FAC/MU/SC/26/2022, faulted the provisions of Section 84, subsection 12 of the Electoral Act 2022 and declared it unconstitutional, invalid, illegal, null, void, and of no effect. Aware that the said Section 84, subsection 12 of the Electoral Act states as follows: no politician at any level, no political appointee at any level shall be voting delegates or be voted for at the convention or congress of any political party for the purpose of the nomination of candidates for any election. Observes further that the judge in his ruling said that Section 84, subsection 12 of the Electoral Act was inconsistent with Sections 66(1)(f), 107(1)(f), 137(1)(g), and 182(1)(g) of the 1999 Constitution of the Federal Republic of Nigeria as amended. Notes that for ease of reference, the sections relied upon in the judgment I stated above are as follows. Section 66(1)(f) says this: no person shall be qualified for election to the Senate or the House of Representatives if he is a person employed in the public service of the Federation or of any state and has not resigned, withdrawn, or retired from such employment 30 days before the date of election. Section 107(1)(f) says this: no person shall be qualified for election to a House of Assembly if he is a person employed in the public service of the Federation or of any state and he has not resigned, withdrawn, or retired from such employment 30 days before the date of the election. Section 137(1)(g) says this: a person shall not be qualified for election to the office of the President if he, being a person employed in the civil or public service of the Federation or of any state, he has not resigned, withdrawn, or retired from employment at least 30 days before the date of the election. While Section 182(1)(g) states thus: no person shall be qualified for election to the office of governor of a state if, being a person employed in the public service of the Federation or of any state, he has not resigned, withdrawn, or retired from the employment at least 30 days to the date of the election. The Senate notes further that Section 4, 1, 2, and 3 of the 1999 Constitution of the Federal Republic of Nigeria as amended vested the power of lawmaking to the Federal Republic of Nigeria on National Assembly and as stated below. Section 4.1. The legislative powers of the federal government of Nigeria shall be vested in a National Assembly for the Federation, which shall consist of a Senate and a House of Representatives. Subsection 2. The National Assembly shall have power to make laws for the peace, order, and good government of the Federation or any part thereof, with respect to any matter included in the exclusive legislative list set aside in Part 1 of the second schedule to this Constitution. And subsection 3 says this: the power of the National Assembly to make laws for the peace, order, and good government of the Federation with respect to any matter included in the exclusive legislative list shall, save as otherwise provided in this Constitution, be to the exclusion of the House of Assembly of a state. The Senate is aware also that in furtherance to the power vested in the National Assembly, the 1999 Constitution, under the rules of the Executive in Item D, that deals with political parties in Section 228, subsection A, B, and C, confers more powers on the National Assembly, more particularly on political powers and effective management of the electoral process by the Independent National Electoral Commission. See as below. Section 228, subsection A says this: guidelines and rules. The National Assembly may by law provide A, guidelines and rules to ensure internal democracy within political parties, including making laws for the conduct of party primaries, party congresses, and party conventions. B, the conferment on the Independent National Electoral Commission of powers as may appear to the National Assembly to be necessary or desirable for the purpose of enabling the Commission more effectively ensure that political parties observe the practice of internal democracy, including the fair and transparent conduct of party primaries, party congresses, and party conventions. And D says this: for the conferment on the Commission of other powers as may appear to the National Assembly, other powers as may appear to the National Assembly to be necessary or desirable for the purpose of enabling the Commission more effectively to ensure that political parties observe the provisions of this part of this chapter. The Senate notes that the Electoral Act 2022 enacted by the National Assembly followed due process of the provisions of the 1999 Constitution as given above. The Senate opines that Section 84, subsection 12 of the 2022 Electoral Act exclusively confers to nominations, conventions, and congresses called for candidate selection and not participation in the general election, with Section 66(1)(f), 107(1)(f), 137(1)(g), and 182(1)(g were referring to. The Senate believes that the interpretation of the meaning of the words civil service and public service as provided in Part 4, interpretation, citation, and commencement in Section 318 of the 1999 Constitution is unambiguous as given below. Part 4, interpretation, citation, and commencement. 318(1). In this Constitution, unless it is otherwise explicitly provided or the context otherwise requires, Civil service of the Federation means service of the Federation in a civil capacity as a staff of the office of the President, the Vice President, a ministry or department of the government of the Federation, assigned with the responsibility for any business of the government of the Federation, while it interprets public service of the Federation as the service of the Federation in any capacity in respect of the government of the Federation, and includes service as A, clerk or other staff of the National Assembly or officials of each house of the National Assembly, B, member of staff of the Supreme Court, the Court of Appeal, the Federal High Court, the National Industrial Court, the High Court of the Federal Capital Territory, Abuja, the Sharia Court of Appeal of the Federal Capital Territory, Abuja, the Customary Court of Appeal of the Federal Capital Territory, Abuja, or other courts established for the Federation by this Constitution and by an Act of the National Assembly. C, public service further means member of staff of any commission or authority established for the Federation by this Constitution or by any act of the National Assembly, government of the Federation. G means staff of any company or enterprise in which government of the Federation or its agencies hold controlling shares or interest. H means members or officers of the armed forces of the Federation or the Nigerian Police Force or other government security agencies established by law. The Senate notes from the above interpretation that there is a difference between the civil service or public service and political appointment. The Senate believes that the Senate of the Federal Republic of Nigeria should show concern on the judgment, especially when she was not given opportunity to represent herself in a matter such as this that emanates from her legitimate functions. The Senate finally believes further that letting the judgment to go without concern will become a precedent on which any person could go to the court and obtain judgment to ridicule the good intentions of the National Assembly as an institution. The Senate accordingly resolved to 1. Follow the appropriate channel and appeal the judgment in suit marked FAC/UM/CS/26/2022 for the court to set aside the judgment, as the judgment was reached without due consideration of the constitutional interpretation in Section 318 of the 1999 Constitution as amended. Mr. President, I so move.
The Deputy